Professor Bhattu Satyanarayan sir in his absentia for his continuous guidance and encouragement in organizing such crucial event for the empowerment of the soil. I extend my sincere regards to respected Registrar Sir in his absentia, Professor R.R. Biradar, for his immense support and well wishes. I extend very warm welcome and gratitude to Professor Dr. Basavaraj M. Kovakadi Sir, Dean, Department of Law, School of Legal Studies, and also Chairperson for today's session. A very warm welcome to respected senior professors, respected Shashireka Maladi Madam, Associate Professor, Department of Law, respected Dr. Jagadish Chandra Sir, Associate Professor, Department of Law, all my fellow faculty members and dear students. We are gathered here to celebrate World Consumer Rights Day 2026, which is observed every year throughout the globe on 15th of March. The theme for this year is Safe Products, Confident Consumers. Now, it is my privilege and honor to introduce Professor Ashok R. Patil, Sir, Vice-Chancellor, National University of Study and Research in Law, Ranchi, who graciously agreed to present before us and via digital medium. Sir has completed his BSc in Criminology and Forensic Science, his LLB and LLM with a specialization in mercantile law, securing first rank, and thereafter Sir has obtained his PhD in Consumer Law, all from Karnataka University. Sir has over 27 years of teaching experience. He worked as lecturer and later as principal at KLD Billard Law College in Belgaum. Thereafter, he joined NLSIU Bangalore, one of India's premier law institution in 2008, and served there as professor for more than a decade. Sir has also served as chair professor on consumer law and practice under Ministry of Consumer Affairs, Government of India. He was founding director of the Online Consumer Mediation Center at NLSIU. Sir has provided expert opinion before several parliamentary committees, amongst which International Ministerial Monitoring Committee on Issues of Misleading Advertisement, Review Committee on Consumer Protection Amendment Bill 2015. Sir has also contributed as member of Drafting Committee for the present day Consumer Protection Act 2019, along with its rules and regulations. Sir is a member of several distinguished boards and institutions, including International Association for Consumer Law, Consumer International at London, United Kingdom, and the International Academy of Financial Consumers at Seoul, South Korea. Not to mention, Sir has presented several papers in more than 15 countries and has 80+ publications in impactful national and international journals of repute. Sir, we warmly welcome you and we graciously request you to address us for the session. Thank you. Thank you.
Thank you, ma'am. Is it audible?
Yes, sir. Yes. You're perfectly audible, sir.
Okay. Echo is coming. Right. Good morning, everybody. At the outset, my sincere thanks to the Department of Law, Central University of Karnataka, Professor Basavaraj Kubkadi, and all the staff members for providing me this opportunity to share my experience on the World Consumer Rights Day. And as already Madam mentioned, this year international theme, Safe Product and Confident Consumer, is very, very important theme. And I will touch upon these matters on this particular point. And as a experience of mine personally, working with NGOs at the grassroots level and working with state governments, central government, bureaucrats, as well as ministers, and involved myself in the drafting of Consumer Protection Act 2019. So that experience I wanted to share on this occasion. As you know, this International Consumer Rights Day started when the UN introduced consumer rights, and that day is considered as a International Consumer Rights Day. In December 24th, we celebrated National Consumer Rights Day, and this is International Consumer Rights Day. When we look into the Indian laws or development in consumer protection, before 1986 Act, there were legislations in which the consumer used to protect, but a lot of challenges were there, and all those cases has to be filed before the civil court. And as you know, civil court is having its own demerits, delay in disposal, heavy court fee, advocate fees, and complicated procedure. So all these things were there. That's why central government thought of bringing the new legislation exclusively for consumers in 1986. United Nations brought consumer guidelines in 1985, and India brought Consumer Protection Act in 1986. And under the Constitution, yes, Article 21, right to life with dignity. It includes right to life without exploitation. So consumers should be protected from all variety of exploitations. So that's why this consumer welfare legislation drafted. And during 1986 to 2019, lot of changes happened. And when 86 Act was passed, we know that in 86, only physical transactions were happening. We used to go to shop and purchase goods. We can touch, feel, all those things we can do. But now the purchase is majority shifted online. Everybody nowadays purchasing goods through e-commerce entities. And also lot of because of digital, all the things day by day, business is shifted to online, and accordingly changes were needed under the 1986 Act. And other aspects, there were two national surveys. One is CUTS International Survey in 2012, and another national survey, IIPA New Delhi, Indian Institute of Public Administration, New Delhi in 2013. And some of the Supreme Court judgments, UP Bar Council case, in which Supreme Court constituted a committee under the chairmanship of Justice Arjit Pashayat. And that team went to all the states, met Consumer Commission presidents, members, NGOs, consumers, and they submitted a report to Supreme Court, and in 2016. So all these things are considered in the 2019 legislation. And even though it was enacted, notified in 2019, but after 1 year, it came into force, that legislation notified by the Ministry of Consumer Affairs in 2020 July. So now another very, very important thing is the law and technology. So now we have to grow with the technology and e-commerce. Yes, day to day we are using smartphones, but purchasing the goods, we have to aware about the e-commerce entities, duties, responsibilities. If any exploitation happened online, how to get the redressal, all those things we should know as a consumer. Yes, Consumer Protection Act is there, but ultimately we consumers have to go through that and take a precautions and go for purchase. If any exploitation happens, yes, under the act provisions are there, then remedies are available, and accordingly we can take remedies. And another artificial intelligence is another new thing is coming up, and everybody knows it. AI, we know AI only for purpose of usually the student use it when the last date of project submission is there, 1 week before. Use AI and you take some data and submit, but it's blindly taking AI content is very dangerous. AI, whatever chat GPT or whatever it is giving you the answer, depending on what is dumped in that particular the software. There are owners of that software and owners collecting data and putting it in that machine. And whatever you are asking questions, depending on what they have put in that machine, the answer will come. It may be wrong also. So that's why as a law students we should be very cautious while using the AI. Yes, it is useful, but we should not blindly believe, trust AI whatever it gives is true. No, it's a sometimes not sometimes majority times it is wrong also. That's why even last month there was a meeting with Chief Justice of India, and even whoever the law clerks, the advocates who are working or students working with the judges, they are also using AI, uh, and their fear is also uh, nowadays students. I mean, AI becoming a master of the advocates or students, which is wrong. So the human being should be a master or control over the AI, not AI should control the human being or one who is using it. So we should be very careful while using AI. And always, yes, in if you use AI, you will get a summary on the point, basic introduction purpose, that is good. But if you want to write a project, if you want to write a article, if you want to make a newspaper article, so then you should be very cautious what you are writing. You have to cross check with original judgments. If it gives you one citation, check that particular citation is existed or not. In one of the Supreme Court, judge asked the citation which was not existed at all. Then the advocate apologized to the court. So that is a very pathetic condition. One must be very careful what we are using. And another aspect about the e-commerce rules and Consumer Protection Act 2019 is very comprehensive compared to 1986 Act, and everybody is consumer one or the other way. And here in India, the consumers are very, not right oriented people. Even though exploitation is happening, they know that it's an exploitation, but even then Indian consumers are not exercising their rights. That's why the the multinational companies, whoever doing business in India, they are not bothered about consumer grievances. The same company doing business in developed countries, they are very serious about quality and safety of the product. But once the same company releases the products in India, they are not serious. There are many reasons. One is in Indian consumers, they are not exercising their rights whenever injustice happens, and that is they taken for granted. Even though out of 100, one consumer may object, so they are ready to compensate that particular one person. 99% jane do, or why I should fight, let others should fight and get the fruit. So like that attitude makes Indian consumers to suffer from these exploiters. So all of you purchasing online products and being a law student, law people, we should be very careful. Just blindly, like a layman, purchase the goods online, and if anything happens, how to go about it, and what are the laws applicable to these e-commerce entities, and there you should be more careful. And under the Consumer Protection Act, e-commerce rules are framed, and in that e-commerce rules, expressly they have mentioned e-commerce, the marketplace e-commerce entity, and inventory e-commerce entity. Simple example for the marketplace e-commerce entity, Amazon, Flipkart, where they are providing a platform and sellers are coming on the platform, and we as a consumers visiting those platform and purchasing the goods. So as a platform, Amazon, what are the duties and responsibilities towards the consumer? That is in detail discussed in the e-commerce rules under Consumer Protection Act. And inventory e-commerce entity is the one where the company itself manufacturing, and the company itself is having a website, and company itself is selling to the consumer. So what is the difference between marketplace e-commerce entity and inventory e-commerce entity? In marketplace e-commerce entity, three parties are there. One is Amazon platform, one is a seller, another is a consumer. Three people are involved in marketplace e-commerce entity. Simple example is Amazon and Flipkart. And an inventory e-commerce entity, only two parties are involved. One is a manufacturer. He himself is having a website, the marketplace, and they themselves selling. Only the manufacturer and the purchaser, consumer is involved. That is a inventory e-commerce entity. It is easy for the uh, identifying liability. There is no third person. But in marketplace e-commerce entity, Amazon is saying, I'm not a manufacturer, I'm not a seller. So you cannot, consumer cannot file a case against the Amazon marketplace. That is the argument made by the e-commerce entities in many cases. But the commission not accepted that argument. See, especially e-commerce entities, they are not doing charity. Amazon is not doing a charity. They are not providing everything free service to everybody. So they are also getting huge profit. They want profit, but when responsibility, liability comes, they want to shift it to the seller. Yes, they have a redressal system online, but even then, if the consumer is not getting the redressal remedy in when whatever injustice he has suffered, then the marketplace e-commerce entity is held liable. So here, one concept on which we worked with the ministry, that is the fallback liability principle. Fallback liability principle. Yes, seller is held liable if seller is not providing justice to the consumer, then liability falls on the platform, marketplace, that is Amazon. So that's why in consumer cases where you purchase some goods and filing a complaint, then you have to make parties One is Amazon or whatever marketplace e-commerce entity. Second one is a seller. Ultimately, consumer wants the compensation jointly or severally. Let them decide who is held liable. Seller is paying the compensation, or both together, or the platform. So immaterial for me, but while filing a case, we have to file against these two people. Another very important thing is, if you look into the e-commerce rules, they have specifically mentioned duties and responsibilities of a marketplace e-commerce entity, then inventory e-commerce entity. And whenever you felt that any of these mandatory clauses are not followed by the companies, yes, that is also deficiency in service. In under the Consumer Protection Act, there are three definitions are very important: consumer definition, then defect definition, and deficiency definition. So consumer, whoever purchases goods or hires service for consideration, that person is a consumer. One exception is there, that is a commercial purpose. If anybody purchases, or the resale purposes, anybody purchases, that is the exception. Then deficiency or defect. Defect is applicable for products. Deficiency is definition applicable for services. So defect definition, it is having a two paragraphs. First paragraph talk about, the whoever purchases goods for consideration, and if any quality, quantity, content as prescribed under the mentioned by the concerned legislation, if it is not followed, then that is a defect definition. That is that product is a defect. Deficiency, again, standards of services are defined under the legislation, then that also not followed, then the deficiency in service. So in products, any laptop, mobile, anything you can bring. And in services, insurance service, medical service, banking service, so those services are there. And each sector is having the specific legislation, and each sector is having a sectorial ombudsman and regulatory authority also. Let us take an example for services, insurance service. In insurance service, there is a regulatory authority, IRDAI, Insurance Regulatory Development Authority of India. And insurance ombudsman is also there. And consumer protection is also there. It is left to the consumer where he can approach and get the redressal. He may approach to the consumer ombudsman or the regulatory authority or consumer commission. So these are the ways available, which is suitable, which is comfortable for him. He can go with that particular thing. And insurance company, usually everybody, you are well aware of the health insurance. After COVID, everybody is very serious about insurances, insurance policies. So health insurance, then life insurance, motor vehicle insurance, everybody is having motor vehicle. And we should know that when we purchase any insurance policies, how many of us are reading terms and conditions? Once you receive it, safely you kept in the cupboard. And when any issue happens, then you take out. Then when the insurance company deny your claim, saying that there is a exclusion clause, you are not falling, you are falling in exclusion clause, hence the insurance compensation is rejected. So at least being a law people, we should, whenever we enter into contract, we should read terms and conditions. And even I'm sure 99% of the whoever purchase the even life insurance or health insurance, these agents comes to you and they will tick the mark. Sir, you sign in every page there, wherever I made a cross mark, and you are busy, sir, I will fill the rest of the data. So majority of the times the agents are filling your data, personal data. If any personal data is wrong, then question comes, the insurance company rejects. on the ground of one of the basic concept of insurance, uberimified, at most good faith, suppression of the fact. So those things are violated. Hence, we cannot give you the compensation. So that's why, being a law people, we should not behave like a layman. And whatever things busy you are, you should go through the terms and conditions. At least you know that what is the exclusion clause, and at least you should fall under that particular clause. So these are the some of the aspects being a consumer we should know. And in defect definition, for example, Food Safety and Standard Act is there. FSSAI is the regulatory authority. It has come out with the standards. So if any food product, if you purchase, if it is not fall under the guidelines or rules under the FSSAI, then you can say that it is a defective product. For example, usually under the FSSAI, they have given a list what type of chemicals can be used, what type of colors can be used, how much percentage, everything is mentioned. If any food manufacturer or the seller, especially youngsters, you like all variety of junk food, and junk food contains all these things. Now you are strong, young, nothing will happen, but it's a slow poisoning. Later, when the old age happens, the side effects, then you will see that particular thing. So that's why you should be very careful. Why mother food, I mean, home food is not liked and outside food is liked? Because mother will not put all these chemicals, colors, all those things. Outside people, they put it, so that's why it is a tasty. So you should be very careful when you occasionally okay, but regular if you eat it. Nowadays a lot of big diseases are coming because of these things, so you should be very careful. And also the e-commerce, now because of the e-commerce, lot of new things are coming. Misleading advertisements are huge, online misleading advertisements. And even endorsers are coming out, hero heroine, they are giving advertisement without knowing what they are saying. The manufacturer or advertiser paying a huge amount, whatever they say, they are saying that. So now because of in the new bill, new act, we suggested endorsers liability. Even before 2019 act, the Maggie case was happened, we submitted a report and requested the central government to file a complaint before the National Commission. And during that time, late Honorable Minister Ramvilas Paswan was there, and he took a lot of pain to bring this particular Consumer Protection Act 2019. And he directed the office to file a complaint before the National Commission. And on misleading advertisement on Maggie, there were other FSSAI case was there, that is independent. And here notices were issued to two actors, one the Amitabh Bachchan and another one Madhuri Dixit, for misleading advertisement. And we put a clause in the act about this, and it was objected in Rajya Sabha, how you can make a actor endorsers held liable. They don't know, they are innocent. Then this was objected by Jaya Bahadur in Rajya Sabha, and Ramvilas Paswan sir said, "We are, I mean, public is trusting you. Before giving any advertisement, at least you cross-check: is it a genuine? This tall claim is genuine or based on some the government lab recognition, given that type of letter. Without that, you should not do that." So now it has introduced endorsement definition as added in the act. Another very important thing is the online fake review. Whenever you purchase want to purchase any goods, you look into the stars, 5-star, 4-star, 3-star, and a review also below. They have given some review who that also you see. That itself is nowadays manipulated by the companies. So there are companies where they tell the product, if this is a package, if you take it, and we will see that your product should get 4 star or 5 star. That type of companies have also come. And also, uh, if negative reviews were put on the web, portal, the company itself is removing that negative comment. They are putting only positive comment. And another thing, they are putting positive comment above, negative comment completely below. Nobody has a time to look into the all the comments. So this is the way they started. And in one of the meeting in Mumbai, the secretary called all these e-commerce companies. I was also there in that meeting, and warned, we will not interfere in the business until you follow ethical rules. If you are not following, then government will enter and come out with the rules and regulations. So in that regard, the ministry came out with the online review standard under BIS Act, Bureau of Indian Standard Act, IS number. Uh, they came out with that particular standard. Now every company has to follow that online review standard, which evolved or came out by the BIS department, Bureau of Indian Standard Department. Then other aspect very important is dark pattern. The dark pattern guidelines are were also issued by Minister of Consumer Affairs, Government of India. These many variety of dark pattern. Some examples I want to give you. When you purchase the product, for example, one mobile you purchased, they mentioned it's a 2 lakh rupees cost, 50% discount you will get for 1 lakh rupees, and you purchased it. When you got the that particular product in a packed form, the original price itself is 1 lakh rupees. The MRP itself is 1 lakh rupees. And online portal, the e-commerce company says it's a 2 lakh rupees, 50% discount, 1 lakh. So when MRP itself is 1 lakh, then nobody can sell for higher. And the company has not given any discount on that. So that is one thing. And another thing, the on the face it says 1 lakh rupees. Then you click the okay. Then at the end, some of the other the addition charges entered, it is coming to 1.5 lakh. So these types of MRP says 1 lakh, and other charges they are putting. So those are also there. So dark pattern rules the ministry has brought, and now we are working hard, and especially Central Consumer Protection Authority is working hard to implement these e-commerce rules, dark pattern, online review, misleading advertisement, all those things. Especially, you know that the Central Consumer Protection Authority is a regulatory authority under the Consumer Protection Act, which was newly introduced under the Consumer Protection Act 2019, which was not there in 86. So this has a very, comprehensive power. Sumoto, it can take the cases, or anybody files a online complaint to the Central Commission, so Central Protection Authority, they will convert into complaint. Only condition what the authority expects. Consumer as a class, it should affect. Individual complaints, it may not be, it will not admit. Consumer as a class, and it should be unfair trade practice. So then they will take it and they will act on that. They have an investigating wing, lot of powers are there, they can do that. So in past 1 year, they purchased online some of the products like cooker, then honey, then helmets. They purchased online sample, and they checked, are they following standard rules and law of the land or not. Helmets or the other aspects without ISI mark, nobody should sell that helmets. And they were selling helmets without ISI mark. And the central authority, they imposed fine on the e-commerce entities also. And there also e-commerce entities said, we are not sellers. Then the authority and in the court, the judges said, in Amazon platform, Amazon entering into the contract with seller, and who is the seller, authenticity, and where he is residing or contact details, commission, everything written in that particular agreement between the e-commerce entity and the seller on that platform. So they know better than the consumer. Consumer don't know. Consumer entering into Amazon or Flipkart, believing Amazon and Flipkart is a trustable. They don't know who is selling on their platform. That's why they cannot escape from the responsibility whenever the consumer is suffering. So that is the important thing. They imposed a fine. And honey, sugar-free honey, and they tested in the lab. They have added sugar also in that. So that also they imposed fine. So like that, the central authority is doing a lot of work. And recently, they misleading advertisement given by these coaching centers in Delhi, in many places. So in March 24th, uh, the ministry requested to write a central authority decisions and what is applicable law to the coaching classes. And from our university, we prepared a book, and that book was released in that particular program. That book is available online also, free of cost. So these are the aspects very, very important. And another very important aspect is nowadays, yes, we are shifting to online business, but these online entities are collecting huge personal data which is not needed. So if I want to purchase a toothpaste or any of these big shops, they want your mobile number, email, hmm, all those things. And they are using it for their publicity, or they are selling that data also. So data privacy is another very, very important thing. After Puttaswamy case, it's a very serious matter, and these companies are taking it very easy. So these are the some of the aspects very, very important. And uh, in the 2012 survey, this Kurz International, they said only 0.03% of the aggrieved consumers are approaching consumer commission, and another 0.12 ombudsman or the seller, and 94% of the people are not approaching anywhere, even though they suffered the injustice as a consumer. So this attitude is, we have to change. And we identified what may be the reason why people, all 94% are not illiterate people. Literate people also not approaching consumer commission. We identified reasons for that also. They think that the delay in disposal happens, and they are busy, they cannot go to consumer commission to file a complaint, all those things. So that's why under the new act, again we have changed to help these people. We have, ministry came out with e-Dakil, online filing of complaint. Sitting anywhere, you can file a complaint online. Second one, where even teleconferencing is recognized. There is some challenge between the central government is very active, but state governments are not that much active, because I'm interacting with all the states. Unless state government provides the infrastructure, it's a very difficult. Act is good, but act is in spirit executed only when state government provides all the digital infrastructure, physical infrastructure, all those things. So there we are facing a challenge, including Karnataka. Uh, the consumer ministry in state, the whole officers, they think that consumer ministry means only ration shop, nothing more than that. Ration shop, grains, or the ration card is a part of the Ministry of Consumer Affairs department. At the same time, consumer awareness, providing infrastructure to the consumer commissions. So this is also their duty, but it's completely neglected. When I was in NLSI of Bangalore, 15 years, I tried to change it. Some things are changed, but majority not changed. And even around 60% of the consumer commission members were not appointed. Then we prepared a report, and I met a secretary, shown that report to her, requested to appointment of those. And during that time, 3 new districts were also formed. And in those 3 new districts, district commission was not there. And I spoke with her for more than 1 hour, but at the end, she said, I have other work to do. Then we cannot fight with the bureaucrats. I said, thank you, ma'am, and came out. And then we discussed with the students. And then we filed a PIL, public interest litigation, before the High Court. And High Court Chief Justice took it serious. And it is a well researched empirical data. And some, notices were issued to Chief Secretary, Secretary Consumer Ministry, and the President of State Commission. And in second hearing, the order was issued, saying that within 6 months you have to appoint these members and establish 3 commissions in 3 new districts. So that is the power of the students. Always when you go to court, Consumer Commission or High Court, they highly respect you. Only their expectation is you try your level best to get first-hand information, empirical research, as on that date, update information. And if something is left, always the judges will help you to come out from that. So that is the way the courts treat, because nowadays public is not having a time to unfair trade practices are happening, but they don't have time to file a complaint. But students, you can file a complaint before the Consumer Commission. There's no need for you to know all the procedural laws, because in Consumer Commission, CPC is not applicable, Civil Procedure Code, Indian Evidence Act is not applicable. Then it is enacted for to help the layman. Layman should come and argue his case. You are law students, you are better than layman. 100% you can effectively make use of that particular opportunity. And always, even our Prime Minister always says our degrees should not be a paper degrees. It should be skill degrees. So during 3 years or 5 years of law course, you should learn those skills, research skills, drafting skills, argument skills, how to handle the clients, mediation, arbitration. All those skills you should learn during your 5 years or 3 years in college. Don't think that I have to pass in these 3 years or 5 years. Once I enter the profession, I will learn. It's a competitive world. If you then also you pass and wear the coat, but again you take another 3 years, 5 years to understand those basics. And in a competition, other people who are expert in that, they are above you. And don't think that National Law School students are great or other university students are not great. That presumption or feeling you should not keep. Everybody is equal, only depending on hard work that will come out. So hard work is the only way for success. There is no shortcuts. So when you are studying any law subjects, you go through the standard book, these guides or law series only for basic understanding, but don't depend completely on that for your examination. So that keep in mind, and always the faculties were there to help you whenever you have any problems. So it's a very noble profession. Whatever maybe you have joined now, but once you join, be serious and work hard, and I'm sure you will be successful, and nobody can stop you. And don't think that law firm is only the way. Even the actually National Law School started in Bangalore in 1986. Professor Madhav Menon started, and I worked under him. And the main object of law schools to start is to strong intellectual advocates, and those advocates will enter into bench. So strengthen bar and bench was the object, but it was because of the change in the market opportunities. Majority of the students are going for law firm. After some years, they are shifting to the litigation. But litigation is the very important thing. Beginning struggle is there. 2 3 years, if you are thorough with your professional skills during 3 years 5 years, that waiting period is lesser. Maybe 1 year 2 years working with a senior you can pick up. But if you are not learning during these 3 years 5 years, then your waiting period after wearing the coat will be 5 years. Then majority of the people will frustrate. You think that how many years I have to work without money, and you think about future, what next? So majority of the people leave the litigation, the practice. They join to some other things. So that's why it's a good profession, but you have to be every day. Another thing is the young advocates. They see the seniors coming in a bench car or big cars, and you also want overnight to purchase a car. ये ऐसा नहीं होता है. That they struggled a lot at the beginning, and now they are enjoying that particular thing. So beginning, you may not get money, depending on how. See, why senior should give you money? If you are useful for the senior, then only. So if you learn drafting skill, if you learn argument skill, you are helping the senior. Automatically senior thinks that yes, this person is helping me, I should give him. So that that type of the skill one must have, then only that is possible. So that's why my suggestion, advice to the law students is work hard. And yes, the student life is a golden life. I'm not saying 24 into 7 you do study only. You enjoy your student life, but balance both the things, study as well as enjoyment as a student. So both should be balanced, and then only you will be achieve what you want to achieve. And beginning, once you join the law profession, uh, I said beginning you may not get money, but if you sit in a court, observe senior advocates, what they are arguing, how they are arguing, how the judge is asking question, and go with a bare act and look into that. So every day you are learning new things. So that is also profit. Not only money is a profit every day. So today I sat in court hall number 1. This is the matter. PIL was discussed, and I was not knowing these concepts. Today I come to know. That is also knowledge gain, is also profit, benefit for you. So think knowledge gain is also equally important, and money later it will follow. Even though you want to stop, it will follow once you are recognized at the top place. No competition at the whatever you are seeing, some advocates standing in a under the tree, you are seeing them and you are telling that no growth or positive attitude will not come. But the busy advocates will not, they don't have a time, because that number of cases are coming. So that's why uh, think positive, and law profession is day by day widening, and technology is very, very important. Technology and language, these two things are very important. Don't compromise. I am also from Karnataka. I also having Kannada Abhimana. But at these, if you want to argue in High Court and Supreme Court and argue with the corporate clients, I mean, discuss with the corporate client, then you should equip with this technology and language. So, in this occasion, uh, I wanted to share my experience because Kalburgi, I'm from Karnataka, from Dharwad, and my love towards to my state and my people always there. If any help from my side, uh, in National Law University, Ranchi, Jharkhand, so always welcome. I'm with you. So with these uh, things, I conclude. Thank you very much for once again, everybody. Thank you.
Thank you, sir. It was such an insightful and thought-provoking deliberations over the importance of Consumer Protection Act, e-commerce liabilities, endorsers liability, and also thank you, sir, for motivating our students to an extent that seeking knowledge is very important. Money will eventually follow. I now request our chairperson of the event, Professor Dr. Basavarajan Gurugadi, sir, Dean, School of Legal Studies, to deliver his final remarks on the event.
Hon'ble Vice-Chancellor, Professor Ashok Patil, sir, and all the respected colleagues, research scholars, and my dear student friends. When we requested from the department, Professor Patil sir accepted our invitation and delivered a lecture. With a short notice, we organized it, and in his busy schedule, also because of love and affection towards our institution, he has accepted and made his time convenient to stay with us. Sir, on behalf of the Department of Law, Central University of Karnataka, first of all, I thank you and convey my gratitude to you, sir.
Thank you. Thank you very much.
Sir has enlightened the different aspects, sir has enlightened us. Especially endorsement of the advertisers. Many a times we believe the advertisers and purchase the goods. Whether there is a deficiency in service or there is any defect in goods, we will not bother. When we purchase the goods, then only we will come to know that it is harmful. And sir also mentioned after COVID, there is a great debate. We being the students of law could worry about right to life. We are purchasing or taking services of different persons which are harmful to our life, and because of which we are spoiling our life, including medicines, including food. If the food includes the poisonous things, we lose our life. As sir rightly pointed out, it may not affect immediately, but slowly it will affect our health, body, and we will suffer with those problems. For that reason, we should not be attracted with the taste or the advertisers. We should look into all those aspects because no one should deprive of our life or liberty except the procedure established by law. That is what. There is no law that the seller should take our life or spoil our life. For that reason, we should be very conscious while we are purchasing the goods or hiring the services from different agencies. With these words, once again, I thank the chief guest and all of you for listening here. And again, we have a different classes of 12:15. Once again, I will not take much of your time. Thank you very much.
Thank you.
Thank you so much, respected Dean sir. Finally, I thank all the faculty members, respected